because that section compels, it's not optional, it compels the court, once an infringement has been shown, to then apply the justification analysis. If a court fails to do that, then the court has acted unconstitutionally. So the only question that has to be asked, was there a right that was limited, yes or no? If the answer is yes, then the court is compelled, impelled, obligated to do a Section 36 analysis. If it does not do so, it is exceeding its powers, because it's not a matter of option or choice. Which then brings us back to square one. The central question in this case will be whether or not the rights that we invoke have been limited, yes or no. If they have been, then one, the court will at least prima facie at that stage have exceeded its mandate, subject, of course, to whether Section 36 will then rescue that infringement. And that, again, there's nothing extraordinary about that. That's what happens to every functionary, every organ of state is susceptible to the very same examination. Did you infringe my right in issuing the tender, yes or no? If you did, then was it justifiable in a democratic society, yes or no? If it is, then that's the end of me as the applicant. If it is not, then I must get a remedy.
Mr. Mpofu, your 10 minutes protection time has expired.
Thank you very much, Justice Khampepe. If I may then continue on that mode. So what we really have here is, if we go, let's start on the first base, then Rule 42. What we are saying is that this court made fundamental, what we call rescindable errors. It's just a phrase that we have coined. And we have coined that phrase, rescindable errors, to distinguish. I'm sorry.
Mpofu, can we, before you get, can you hear me?
Yes, I can hear me. Yes.
Is the remedy of rescission available to a litigant who deliberately decides not to oppose an application?
Yes.
And I'm asking this question because in Freedom Stationery, the Supreme Court of Appeal said that when you take a considered view not to participate in proceedings, you are reconciling yourself with whatever decision a court will make. So this is against that background that I'm asking this question.
Yes. Thank you, Justice Chik. Yes, that's a very important question, because it will help us to quickly get rid of one of the defenses that have been raised along those lines. Well, let's start. Bear in mind then, Justice Chik, that as I've said, that we rely on the rescission section. We also rely on Section 38. We also rely on Section 172. But let's answer this within the strict confines of the rescission. Firstly, the answer is, of course, yes. It cannot be that if X owes Y some money, and then X goes to court, and Y decides, well, I'm not going to oppose this because maybe I know that I owe the money, or I owe 100 Rand and so on. Deliberately so. And then the court gives judgment for 1,000 rand, let's say, or whatever, or even says you must give him the car and the house and everything, then it means that Y cannot then approach a court to rescind that judgment, which is clearly erroneous for some reason or another. It can't be. So the issue of whether you have consciously decided not to defend is really, cannot non-suit an aggrieved defendant, respondent, and so on, who, having accepted that either the court, this is a frivolous thing, the court will not even look at it and so on. And the court actually does look at it and says, well, you must give him the house. Then at that point, it cannot be said that that litigant cannot approach a court for a rescission. That's the first answer. The second answer is that rooted in this notion, and this is a more constitutional answer, if you like, rooted in this notion of voluntary non-participation, as we've called it in our replying affidavit, the defense of voluntary non-participation, is lacking behind it is a concept of waiver. It's been expressed in many ways: waiver, election, peremption, condemnation, whatever you call it, estoppel. It doesn't really matter what you call it. But that can never apply. There is authority for the proposition that constitutional rights, which is what we're here to assert, cannot be waived, or at least certain of them. And those include unwaivable constitutional rights, include the right to a fair trial, which is the flagship right that we are about here. So the particularly in a case such as the following, such as this one, where it is the Constitution itself, the supremacy of the Constitution itself that is being asserted, a litigant cannot not be non-suited. In other words, you cannot say, well, you have forfeited your rights to life, for example, simply because you did not oppose a particular, and we say this in our heads, Justice Shikwi, we deal with it in where we deal with the waiver point. And we quote S versus Makwanyane, paragraph 137 of S versus Makwanyane, which makes it very clear that constitutional rights, such as the ones we are asserting here, cannot be waived. I'm sorry if I can just find them. Yes, paragraph 49 of our heads, at page 16. We say, to save time, we must now turn, at 47, turn to the repeated defense raised by the respondents in refrain mode that the applicant was the author of his own misfortune, since he spent many opportunities to participate in the proceedings, which is a variation of the question you're putting to me, Justice, which resulted in the arrest and committal orders. According to this logic, it therefore does not matter whether the applicant's rights are irregularly infringed or not, because, quote, he asked for it. This argument misses the point only by the proverbial mile. It also offends the value of Ubuntu. We do not stoop to the level of those who offend us. The rights in the Constitution are mostly unqualified. They must be extended even to the worst among us. These rights cannot be forfeited, neither can they, generally speaking, be waived. These principles were established in the seminal judgment of S versus Makwanyane when Chaskalson P. authoritatively stated that, quote, constitutional rights rest in every person, including criminals convicted of vile crimes. Such criminals do not forfeit the rights under the Constitution and are entitled, as all in our country now are, to assert these rights including the right to life. And then we go on to quote a passage from Curry and Deval in the next paragraph, which makes this point about non-waivable rights. Those authors say, in contrast to the freedom rights, in other words, like the freedom to participate in a political party, the freedom of association includes, as we know, the freedom of disassociation. So nobody can say, well, you have the freedom to join a political party, and therefore, if you don't join a political party, you are infringing the right, because it's a waivable right. So it says, in contrast to those rights, the nature of the rights to human dignity, to life, the right not to be discriminated against, and more importantly, the right to a fair trial does not permit them to be waived. Unlike the freedom rights, these rights cannot be exercised negatively. The right to freedom of expression, for example, can be exercised by keeping quiet, but the right to dignity cannot be exercised by being abused. What that means is to just complete the thought, is that insofar as that question is aimed at some kind of waiver or the fact that you did not exercise your rights, therefore you must live with it, as it were, then it is a precursor to these defenses that have been raised by the first and second, the HSF amici, of so-called waiver, election. You'll find that the word election litters their heads of argument, and preemption and so on, but those are expressions of the same idea.
I'm sorry to interrupt you, Mr. Mpofu. Let's just stay with the right to a fair trial. My question basically stems from the fact that here, the former president was notified that there's an application that is brought before this court.
Yes.
He was aware that the order that was being sought was to hold him in contempt.
Yeah.
And I'm going back to your example where you say that a person claims 100 rand and then a judgment would then give an order of 1,000. Here, what was sought was an order to hold him in contempt. And this court did not grant an order not to hold him in contempt, but a different order. It gave an order to hold him in contempt. So let's stick with that. And this is why I'm saying he knew that the application here was to hold him in contempt. Yeah. And he elected not to participate. And that is the order that this court gave. It granted an order to hold him in contempt.
Yes, Justice Chick, I understand. That's exactly the word you've used, elected. Election in law means the same thing as condonation, waiver, estoppel, acquiescence, whatever you call it. There are many words, but it's the same word. So the doctrine of election and the doctrine of waiver and the doctrine of acquiescence, the short answer to your question is that those doctrines do not apply when you are asserting the rights that I've just listed, including the right to a fair trial.
So in all instances, then, in all courts, if we are with you, would basically be saying that it is okay and open to a defendant to simply sit back and hope that a judgment will be against or in his favor or against the plaintiff. And that when that judgment is against them, then they can come to court and use the remedy of rescission.
No, Justice Chick. No, what that defendant you are talking about is entitled to do is to, as you put it, simply sit back on the comfort or in the comfort that the court will not give a judgment that says, for example, if someone goes to court and says they want to declare me to be an illegal immigrant or whatever, then I can say, well, I'll exercise my right not to oppose that, because I think that there's no court that's going to find that, and so on. That's fine. I'm entitled to that, right? Now, that's not the question. The question is what happens once the court then declares me an illegal immigrant? Am I now remediless simply because I knew that person who was taking that to court? Surely not. That cannot be the law. It can't be the law that I'm now completely helpless. I must just live with my election and move to some country that I don't know. It simply cannot be our law, just even at the level of logic. Surely, particularly when you are exercising constitutional rights, the point at which you perceive your constitutional rights to have been abrogated, whenever that point might arise, whether it arises at point 1 or point 25, doesn't matter. But at that point, when you perceive that your rights have been infringed, you have a right to seek a remedy. Ubi remedium, ibi jus, ubi remedium. So there cannot be a right that has no remedy. So if I have a right to assert my constitutional right at any point, even on my deathbed, one cannot say, oh, well, you should have done so when you were still healthy and so on. Otherwise, the rights in the Constitution are hollow and meaningless if they cannot be asserted in a court of law at any point, Justice.
Maybe I should stop here because maybe I'm not understanding the elements of rescission or what needs to be proven by an applicant in a rescission application. Maybe I'll follow that up later.
Yes, thank you.
Thank you.
Mr. Mpofu, can I raise 3 aspects with you, please?
Yes, Justice Machit.
The first one emanates from your opening address, where you said that you're bringing the application under further and alternative relief. When I read the papers, and it's made clear in paragraph 1 of your notice of motion that you seek rescission based on Rule 42, read with Rule 29 of this court's rules.
Correct.
So must I understand that when you raise these other aspects, you are raising it on the basis that Rule 29 suggests that Rule 42 must be adapted, must be modified as necessary. That's the basis. I just want to get that clear.
Yes, the answer is yes, Justice Machit.
Yes. So ultimately, we are still looking at Rule 42, modified where necessary.
Yes, modified. Yes, that's correct, Justice Machit. Yes.
All right. Now, thank you. The second aspect is this case that both you and Mr. Ngowana cite, and the SCA that gave judgment 2 days after ours.
The De Beer case.
In Minister of Kokta versus De Beer. We're not talking about the same thing, are we? That's a case of scandalizing the court. What had happened in that case is that there was a summary procedure employed. I'm talking about Mama Bolo now. And in this case, what the SCA did was, in giving judgment on the challenge on the state of disaster regulations, at the end, the court said, Mr. De Beer wrote an insulting letter to the President of the court and other justices, and therefore they referred the matter to the NPA. That was a case of scandalizing the court. It's a case similar to Mama Bolo and to Machabeng in this court, isn't it? It's completely different it's completely different from the disobeying of a court order that we're dealing with here, isn't it, Mr. Mpofu?
It's not completely different. It's another species, yes, of contempt of court. That I will concede. But to say it's completely different, especially in relation to the rights of the accused, quote unquote, would be stretching the point, Justice Mitchell.
In Mama Bolo, this court was dealing with an official of correctional services who had said some insulting remarks about Judge Els in the Eugene Terblanche case. And in that case, this court had to consider whether the summary procedure of contempt was constitutional. And the court pointed out there that it's a species of criminal contempt. And the same in Machabeng. It was a case of criminal contempt. We are not dealing with criminal contempt here. We're dealing with civil contempt. And the judges make that quite clear. You can read Machabeng at paragraph 50. And you can read Mamabolo at paragraphs 34, 35, and paragraph 53. If you want to, we can go through it. But the point that I make is we are dealing here with a different species. It's civil contempt. And civil contempt has been tested in this court, the constitutionality, and it has been declared in PECO as to be constitutional as in Faki, where a court deals with it on motion procedure, isn't it? So that case is completely distinguishable.
Okay, well, that's where we differ, Justice Machit, with respect when we say completely distinct. It's not complete. They're different species of the same thing, or genus of the same thing. Criminal contempt is a crime. Civil contempt is a crime, right? So we're dealing with two crimes. The fact that it's like if you said, I want to assert my Section 35 rights, then you say, no, but the other person was charged with bank robbery. You are charged with murder. It doesn't matter. The Section 35 rights apply to crimes, any crime in this country. That's the principle that we seek to assert. We're not saying that every crime is the same. In fact, not even every murder is the same as another murder. So we accept without qualification that two crimes. But are they crimes? Yes. And if they are crimes, does Section 35 apply? Yes. If it does, was it infringed? Yes or no? If it was, did Section 36 apply? Yes or no? That is really, this case, despite all, it looks like complicated, but it actually is not. It is a simple matter of whether in a crime of whatever description, the rules were followed. If they were, they were. If they were not, they were not. It's really that simple.
Right, let's agree to disagree then. It's paragraph 53 of Mamabolo. Krishla J says the following. Now remember, we are dealing with scandalizing of the court.
Yes.
As you say, as a species. Krishla J says the following, quote, a person so summoned for scandalizing the court is an accused person as contemplated by Section 35(3) of the Constitution.
Yes.
And in PECO, this court made it very clear, and in Faki, the SCA made it very clear that a person in this instance of disobeying of a court order in a civil contempt proceedings is not an accused person for purposes of Section 35(3), although some of those protections may be afforded to that person. Do you accept that?
No, not at face value. Let me explain, Justice Majid. And this is where the problem really is about some of these descriptions. In Mamabolo, I think the word that is used is combination or dual nature. And then
that's in PECO, Mr.
Yes.
Mr.
Well, yes.
Mamabolo was
Let me just say this court.
Mamabolo was not dealing with civil contempt at all. You're talking about PECO.
Yes, whichever. Faki, PECO, Machabeng, doesn't matter. The point here is this. Is the hybridity of these proceedings is often misunderstood. Maybe that's why I'm using that word. The word hybrid might well not be the right word, because, or amalgam, as Justice Kampepe called it in the judgment here. Because an amalgam, as we know, is something which is intractable. So it's an amalgam of certain things. That's why I prefer the word combination or the dual nature, because it's very confusing, this idea of the amalgam. When we say it's a combination, it makes it clear it's a combination of two things, of civil proceedings and criminal proceedings. Now, that is why in Faki they use the word accused in quotes. They say the accused. If you go to paragraph 24, 25 of Faki, it talks about the accused in quotes. That is simply because in that particular context, of the entitlement to Section 35 rights, the person is obviously an accused, must be regarded as an accused person. It would be foolhardy to talk about Section 35. Section 35 rights are only available to accused persons, by the way, which is what this court said in Zuma 1, in this case, the judgment of Chapter J, correctly, if I may add. So you cannot be entitled to Section 35, if you are entitled to Section 35 rights, then for that purpose you are an accused, full stop. But you are also, because of the unique nature of these proceedings, you are also a respondent or an applicant or whatever in the civil context. But that does not denude you of your status for constitutional purposes as an accused person, right? Now, and that is why you are dealing with so for a minute, you have to conceptually forget that you are also called the respondent or the applicant and say, now we're dealing with you for the purposes of criminal purposes. You are an accused, and you have to be entitled to all rights of every other accused person in the country. And that is why that distinction is artificial for the purposes of what we are discussing here. So whether it's scandalizing the court or whatever it is, insofar as you are an accused, you are entitled to section, which takes us to De Beer. The De Beer case is an illustration, because we must substance over form. In substance, what Mr. De Beer was accused of doing is exactly the same thing that that former President Zuma is accused of doing in his statements and all that scurrilous attacks and what have you. So that's the reality.
Sorry, Mr. Mpofu, I don't like interrupting counsel, but can I just stop you there? Mr. Zuma wasn't sentenced because of the insults and the vilification of the judges or of the judiciary or even of the court. He was sentenced because he was in contempt of a court order, of the order of this court.
No,
yes.
No, I'm afraid that is absolutely not the case, Justice Bachid. We are told in more than 5 passages that what makes this case unique and extreme and so on and unprecedented are the attacks that were made by former President Zuma. We can both go to the judgment. I'll find you not less than 10 passages that refer to that. That is why the minority judgment says, let's conceptually assume that there were not those scurrilous attacks. What would we be left with? We would be left with what you are saying it is, a normal contempt of a court order. But there can never be any denying that in this particular case, what was being punished was even more than the disobedience of the court order. The egregious, scurrilous, and all sorts of adjectives that have been used so to separate that, which is really the thing that took him to jail, rather than I'm now not talking about. Let's assume he's guilty of not.
Well, sorry, can I stop you there? You see,
yes.
We're talking about 2 different things, Mr. Mpofu. You're talking about sentence. I'm not a sentence. I'm talking about his conviction. All I'm saying to you is Mr. Zuma was convicted not for vilifying the judges of this court or the court itself. He was convicted of contempt of court because he disobeyed an order of this court. And that's what the minority also says. That's their finding. Do you accept that? We're not talking about sentence. We're talking about the conviction. Do you accept that?
No, I don't accept that you can separate it like that, Justice Machit. I accept that the convict. That's why I said assume for a minute that he was correctly convicted, because I was avoiding that kind of debate. If you assume that he was correctly convicted, that's the point I'm making. Then, of course, even the conviction for that matter, I don't think it can be dissected to say he was only convicted of the one part. But let's assume for argument's sake that that's the case. The point that brings us here is that throughout his trial, quote unquote, his Section 35 rights were denied, right? Whether you are talking about the conviction stage or the sentence stage, the question that must be answered, where is Section 35 rights denied, yes or no? They might have been denied in stage 1, stage 2, stage 20, or both, or whatever. That's not the level at which we're pitching.
No, Mr. Mpofu.
Yes, Justice Matlanga.
No. You are moving to a different point altogether. Of course, you are entitled to argue that point, and I accept that it goes to the heart of your argument. But that's a different point altogether to what my brother Justice Majid is raising with you. And I do not think it's something that we can simply gloss over. I agree with my brother, subject, of course, to responses that you may give. You are conflating two totally different issues. My brother is saying the conviction itself related only question of disobeying this court's order. You are quite right in saying that this court judgment, the majority's judgment, is replete with references to Mr. Zuma's conduct, his utterances, and so on. You are quite correct on that. But what my brother says is that is a totally different issue. Those references relate to the question of sanction. So it is not correct for you to say, in making your point that the matter of Mr. Reino de Beer, either basically the same as this one or similar to this one, to say that Mr. Zuma or former President Zuma was also convicted of something, or rather his utterances, just like Mr. Reino de Beer was. The short point is, as you correctly say, yes, this court, the majority does refer to those utterances, but it does so and relies on them in the context of sanction. If you insist that it does so even with regard to the question of guilt, I would ask you to show us in the judgment where we say, or where the majority says, we find former President Zuma guilty because he said this and that and that. The conviction relates only to, there was a summons for former President Zuma to appear, he did not appear. That is the basis of the conviction, not the utterances. And it's on that basis that my brother Justice Majid says, this case, therefore, differs from that of Mr. Reino de Beer.
And Mr. Mpofu, before you answer, can I ask you to look at paragraphs 43 and following of the judgment of Kompepe J, the majority judgment, please?
Okay, no, that will not be necessary. Maybe it's me who's not articulating this correct. I don't know why I'm being told that the conviction was only for the. I said that many times. That's why I said let's accept for a minute that he was correctly convicted. But in case there's any ambiguity about whether I accept that the conviction was only about the court order, all you need to do is to go to paragraph 3 of the order issued by this court. It's very clear. It says it is declared that Mr. Zuma is guilty of a crime of contempt for failure to comply with that order. That's not the point I'm making. I accept that. That's why I even said, assume that is even a correct conviction. I went further. So I don't argue anything different. All I'm saying is this, that notwithstanding, what is undeniable and what we have come to this court for is to say that even, and it's said that it's in the founding affidavit, I don't know which paragraph, we say, even in a situation where you would say that the conviction was correct, we don't accept, of course, that the conviction was correct. But we say for intellectual debate purposes, even if you accept that the conviction was correct, the Section 35 rights that we have come to assert would have been infringed in relation to the sentence. So we would have been entitled, as the judges know, sometimes people go to the SCA or wherever and say, I've just come here to appeal or to rescind or to do whatever, or review, whatever it is, the sentence, not the conviction. So I'm prepared to say, for the sake of argument for now, let's not dissect this thing between the sentence and the conviction. Let us say where Mr. Zuma's Section 35 rights infringed, yes or no. Whether this is what I was saying, whether they were infringed at this stage or that stage or the other, for now is not the point we're making. We accept, Justice Majid, without any qualification, that order number 3 of this court was specifically confined to the issue of
Thank you, Mr. Mpofu.
Breach of the order. But what we're saying is that the committal order, it would not be the same thing. To say that is not the same thing as saying the arrest and committal orders were confined to the order of Zuma 1. That one is certainly not true. Now the only
Mr.
point that I
Mpofu,
want to make about
Mr. Mpofu, just Mr. Mpofu, can I judge in there? Just on the distinction between De Beer and this matter.
Yeah, right.
Does it matter that Mr. De Beer was not a party to contempt proceedings, number one? And also the fact that his conduct or his statements were made after the hearing, but before the judgment. Is that a factor that are those two factors that we can use to distinguish De Beer from this matter? First one, and more important for me, the fact that here we specifically had contempt proceedings, and the former president was a party to contempt proceedings. And the fact that in De Beer, after the hearing, during his correspondence with the registrar of the Supreme Court of Appeal, he then made those statements. Is that a distinguishing factor?
Of course, no two cases are the same. Those are distinguishing factors. The question is whether those are material distinguishing factors for the purposes of what we are here about today. And my answer is a big no. And let me explain, Justice Chick. Of course, as you know, this happened, this one said this at a particular time. But the point is not that. The point is this. When a person, and that's why this distinction that Justice Bachit and Justice Madlanga were making becomes important. Because ultimately, it would be, let's assume Mr. De Beer and former President Zuma, for whatever they did, both end up in jail or having paid a fine or whatever it is. When they are there, when they are detained, no, they're not going to say, oh, well, I'm here because I was in the court and I spoke to the registrar and so on. At that point, their right to freedom, to personal freedom, has been equally infringed because they'll be in the cell next door. The one will be in the cell next door. So that's really where we must look at this problem, not at the artificial levels of the differences of how they got there. Now, here's the question. And it goes to the point I was making about Section 172. This court in particular is enjoined to protect the rights of all of us. So this is what the De Beers case raises. If there are two ways in which those rights can be protected, one, let's call it the Zuma way, and the other one is the De Beers way. Which one protects the rights of our people? Is it the route where do not pass begin, go straight to jail, no trial, no mitigation, no appeal? Or is it the De Beers way, which says the matter is bad, you've been scurrilous and all that, but you're going to go to the magistrate's court, you're going to go to the High Court, you're going to go to the SCA, and maybe you'll end up in the Constitutional Court. Which of the two is the discharge of the duty of this court to protect the rights of those two people, Mr. Zuma, Mr. De Beers, standing in front of you, both of them? If the court chooses to adopt the Zuma way, then it is exceeding its powers, it is abrogating his rights. If the court, as the SCA did, chooses the De Beers way, then it is vindicating Mr. De Beers' right. It is that simple. And secondly, the issue is this, and that is why the minority actually coincidentally suggested what we call the De Beers way. So what we really have here is that within the space, and this case is unprecedented in that fashion as well, within the space of 48 hours, 7 judges preferred the Zuma way, and the 7 judges preferred the De Beers way. That's where we are as a country.
Sorry, Mr. Mpofu, I must take issue with that.
Yes.
You say in your heads, even if De Beers, you and I disagree on it, but as I see it, De Beers is scandalizing the court. It's a completely different case. You say in your heads at page 4, paragraph 8, significant differences in the approach of our 2 highest appellate courts in the handling of similar crimes require some attention. Now, even if De Beers was on point, if it was comparable to this case, then obviously the doctrine of stare decisis would have meant that that court would have been bound by this court's decision, isn't it? So it would have been irrelevant anyway.
Yes, you see, of course, you are right, Justice.
Because there's no 2 appellate courts, highest appellate courts in this country, Mr. Mpofu. There's only one. It's the apex court. It's been like that for 8 years, 2013.
Yes, no, Justice Majid, you know, at the level of technicality and ranking the courts and all that, you're 100% right. But that's not the point I'm making. I know very well about stare decisis. What I'm saying is the following, that 2 crimes, and I have to go back to this, because this one was scandalizing the court. The word similar means exactly that they're not the same, right? But the point I'm making is that 2 persons, let's forget the technicalities and the Latin, 2 persons who have done the same thing. One is dealt with in a way that vindicates their Section 35 rights, and they get a trial, a proper trial as we all know it. The other one does not get that trial. It's the same as the distinction that is made with respect artificially about the case of P.W. Botha. Of course, P.W. Botha was charged under the Commissions Act. Of course, we all know that. But what is it? Let's forget about these artificial things. What did P.W. Botha do? He defied a commission of inquiry. What did President Zuma do?
All right, let's now cut out of that constitutional court hearing deciding the fate of former President Jacob Zuma, who's incarcerated at the Estcourt Correctional Services. And we now